Now I'd like to introduce a very special guest tonight. Steve McDonald has practiced environmental law since the 1970s and has represented clients in landmark cases at the federal and state levels, including the United States Supreme Court. He was a co-founder of the environmental law practice at Latham & Watkins in the 1970s and at Luce Ford Hamilton and Scripps in the 1990s. In 2008, Mr. McDonald opened his own law office in La Jolla. Mr. McDonald handles lawsuits and administrative enforcement proceedings involving air and water quality, hazardous waste management, Superfund site cleanups, and natural resource damage claims. He spends considerable time in counseling on all types of environmental issues and has handled a wide variety of real property and commercial litigation. He has represented a wide range of clients, corporations, individuals, public interest groups, Indian tribes, and governmental entities, and tonight he's here as a community service. Thank you, Steve McDonald.
Thank you, Lana. Vanessa gave a very good overview of the history and many of the concerns raised in the community about the Sunrise Powerlink. What I want to do is give you how this fits into legal challenges that might be raised or have been raised against the Sunrise Powerlink and give you some idea of the approvals that are still yet to come. Essentially, we've got several different forums fora where there's still decisions to be made, and the California Public Utilities Commission, the Supreme Court in California, and the Court of Appeals in California are three places that will still have to make decisions on Sunrise Powerlink. On the federal side, you've got the Bureau of Land Management, which is undergoing an appeal right now. The U.S. Forestry Service, which still has to make decisions on its forestry plan, and then ultimately, should the decisions not come out properly, then federal courts will then be reviewing those. There's also a number of other jurisdictions that will have various other permits that I'll talk about here in a little bit. On the state side, Vanessa touched on this. In December, the CPUC granted the Certificate of Public Convenience and Necessity for construction of the Sunrise Powerlink. The Utility Consumers Action Network and the Center for Biological Diversity in Sierra Club then filed applications for rehearing. That decision on whether or not there'll be a rehearing is still pending, and we expect that to be issued June 18th, next week. Theoretically, they could actually decide that the arguments that were made were valid and say we need to go back and rehear this. I think practically, in our experience, that we wouldn't expect that to be the case. The anticipation is that the rehearing decision will probably try to provide more rationale and support for the decisions already made, and then that would start a clock, or two different clocks actually, dealing with that decision. One is a 30-day clock, and that clock deals with appeals under the California Environmental Quality Act. And many of the issues that Vanessa raised dealing with environmental issues have to be made to the Supreme Court, and I'll discuss the primary issues that are on the table in just a moment. There's a second appeal period that is running, and that would be the appeal period to go to the California Court of Appeal or the Supreme Court, depending upon choice of filing. That would be challenging the underlying decision, not just the environmental issues, but the underlying decision of the CPUC. Did they do their economic analysis properly? Did they look at the alternatives properly? And did they follow the law under the Public Utilities Code in approving that plan? But until the decision for rehearing comes out, we're essentially awaiting to see how they try to recast their decision and see where we go from there. The primary issues on the state side, in the California Environmental Quality Act, these are the type of issues that were raised in the petitions for rehearing that will be on the table in the Supreme Court after the rehearing decision comes out. As Vanessa said, this is essentially sort of recapturing many of the issues she just raised. No requirement for renewables. The identification and the analysis of the finally selected route, all the action was up at the north, and then all of a sudden at the end a route showed up that was never really identified in the public documents for environmental review, and you did not have the adequate opportunity to comment on that and for them to consider that. That's one of the principal issues that's been raised before the CPUC. Other issues include the alternatives analysis, and not just alternatives in terms of the environment, but alternatives in terms of, do you even need to have this line? That's sort of a crossover issue. There's both environmental issues related to that, as well as an issue is, do you really need to have this line in order to protect the power needs of San Diego? Some other issues have to do with greenhouse gas emissions and the way in which they considered the amount of greenhouse gases that may actually be increased by this line, even though there was a suggestion that it might decrease it. Unfortunately, as was mentioned, there's no requirement whatsoever that they have any renewables on this. And the analysis for greenhouse gas emissions is just woefully lacking because they didn't really consider what can happen. And the line itself may ultimately increase greenhouse gas emissions overall as a result of this line, and which would have to be offset by other actions, either by SDG&E or someone else. Another issue is the proper standard of review. Did the way in which the CPUC considered the arguments, who had the burden of proof in showing whether or not environmental issues would be adequately mitigated. We really need to have the rehearing decision before that can proceed, because that rehearing decision may recast some of these issues. It may make them different. Some may go away. And there's always, you can always say that maybe they'll actually rehear something, although that's really not anticipated. And this again is an action that would have to be filed in the California Supreme Court within 30 days after the decision comes on rehearing. Now, also on the state side, there's other permits that would have to be obtained by them. The Regional Water Quality Control Board will have to look at water quality impacts and do a certification on water quality under what's called a 401 certification. There are a lot of issues related to cultural resources. Since the southern line was not completely studied in terms of cultural resources, there are a lot of issues under both state and federal about impacts on both prehistoric, like Native American cultural resources, and other historic structures that may be affected by the power line. Department of Fish and Game must still weigh in on impacts on endangered species, for example. There have already been some biological opinions by the Fish and Wildlife Service. Some of those, however, have been challenged as to their adequacy. There also may be some other permits. I haven't tried to list everything, but essentially when the CPUC approves the power line, that just gives them the authority to try to put a power line between point A and point B. They still have to go to every land use jurisdiction, federal, through the forest, through BLM, through any other jurisdictions, and get their permits. But the big ones are really, BLM, the Forestry Service, and obviously having the CPUC certificate in order to proceed with the power line.